Nancy. So to echo what Nancy said, welcome everyone. Just as a brief overview of Goodwill, just in case those of you aren't familiar with us, we have over 25 years of experience helping over 2,000 businesses from a variety of industries grow or scale in the UK. We help our customers understand the complexities of UK business culture, and the core five departments that Goodwill cover are HR, so Helen and I are here today, payroll, finance, governance, virtual office, and across those areas we have business advisors who are skilled in those specific areas and work with any partners for any areas where we can't assist in-house, so that we are able to give a full service offering. So Helen and I are here today from the HR department. We again offer services to cover the full employee life cycle. So that will detail from inception to that employee to the exit and everywhere in between. We also help with global mobility needs. So if you are looking to bring individuals or teams from overseas, then we can help you with secondments and sponsorships for those individuals and for your company. So in terms of what we're looking at today, the topic, as you were aware, is employment law updates and what further developments have been revealed to be coming in the Employment Rights Bill. So we have been speaking about the Employment Rights Bill and the proposed changes for quite a while now, I think it's safe to say. But eventually, at long last, it is expected to become law later in 2025. So there are going to be a few changes happening in 2025 itself, but most changes will be happening in 2026 and 2027. So we just thought it was important to give you an overview of how the employment law changes work in the UK, because again, that it might be a matter of confusion for those of you who might have joined our previous webinars on this topic. So the bill is currently going through Parliament. There may be further changes added before those proposed changes become law. So when it does become law, the bill will introduce additions and amendments to existing legislation. So that will include things like the Employment Rights Act that you might already be familiar with in the UK. But to become law, the bill itself needs royal assent. So this is when the King formally agrees to make the bill into an Act of Parliament, and this is expected sometime in autumn 2025. So just to give you a bit of an idea of the journey of where we started talking to you about some of these changes, where we are today, and now we finally have a better idea of when these particular legislation changes will come into play. So the agenda points that we will be discussing today are immigration, unfair dismissal and redundancy, pregnancy, family and welfare leaves, flexible working, tipping, 0-hour contracts, fire and rehire, harassment, and trade unions. So I think I'm going to kick us off first on immigration. So the first point to make is we did say we were going to talk about the Employment Rights Bill. This piece of legislation is not part of the Employment Rights Bill, but very important to mention to you nonetheless. So if you are not a UK passport holder or you have a visa through another route, and don't have a visa through another route, and you want to travel to the UK as a tourist or for business purposes, then you will now need an electronic travel authorization, shortened to ETA, to enter the UK. And this is similar to a US ESTA. So we've spoken about this before, but the scheme has now finally rolled out after some delays, and this happened in April of this year. And this covers Britain's various modes of international transport. So if you're coming to the UK via plane or ferry or train, you will still need an ETA for clarity. So if you or any of your team need to enter the UK on a short-term basis for business, then there are a short list of permitted activities available to be executed in the UK without a work visa. But the list is very short, and the maximum time available to be spent in the UK is 6 months under this type of entry. So there are rules around this. I won't discuss them now because it is quite technical, but I just really wanted to point out or highlight that those travelling from EU countries and some countries outside of the EU as well would need to apply for this ETA, and the ETA itself would be considered your business visa if you are travelling under those rules. So there wouldn't be an additional application required in addition to this ETA. But do be prepared for questions from border control on why you're in the UK, when you're leaving, and so on, to satisfy border control that you're not here doing something that you shouldn't be. The ETA itself must be applied for at least 3 days in advance of your travel. It's attached to your passport and it's valid for 2 years. So if you want to renew or replace your passport within that 2 year period, then you would need to apply for the ETA again. The key point is that it does not replace a right to work in the UK. So the ETA itself is not a right to work. It is not a work permit. There are different types of routes for visas in the UK, and this is not intended to be a 101 session on visas, but just obviously key point to raise. If you do sponsor employees or you want to sponsor employees, then you should be aware that the UK government has introduced significant changes in July 2025. So the focal point has been on the level of roles that are being sponsored, and there has been a push to only permit sponsorship for roles that are at bachelor degree level up over. So they're considered to be what we call an RQF level 6. And on the permitted job occupation lists, there have been over 180 roles cut from those lists. There has been a temporary shortage list introduced, where there are limited roles available to be sponsored under those particular job types. They only last until December 2026, so you can only apply under the temporary list until December 2026. The list is very short, and there are no dependents permitted to accompany the sponsored migrant on this route. The care worker route has closed to new entrants, and under the skilled worker route, the minimum salary requirements has also increased to 41,700, and that's 33,400 for new entrants. So that's still quite a shift on both immigrant like new entrant level, and then on that would be on a 37.5 hour working week, and that's across many job codes. And there are also increased costs across the Home Office services in general. So there is an increase on the certificate of sponsorship up to £525 per certificate of sponsorship, and that's an increase from 239. And then the visa costs themselves, so the cost to the employee when they make their visa application, there is an increase between 5 and 10% for this. So that will vary depending on what visa type that they are applying for, but that's still quite a chunk of an increase. What that means for you as an employer. So as mentioned, there are significantly fewer job codes available. It will become more difficult to sponsor many roles. And in certain industries, it has become very problematic. So as an example, as I did raise, the care industry, you can no longer sponsor individuals. In the hospitality industry, chefs can no longer be sponsored. There is no possibility to bring restaurant managers, bakers, and so on. It's really important to review your job descriptions against the job code lists. You would need to look at the salary levels for renewals and new migrants to make sure that you can pay what is being required by the Home Office now. And if you don't already have a sponsor license in place, then it's likely to become more difficult to get one. I'll pass you over to Helen now to talk about day one dismissal rights.
Thanks, Jackie. So I know if you've joined previous webinars we've done on this topic, we've talked about these changes as previously, and as Jackie said, we thought it was important to give a recap on what the current rules are, but also we have now a bit more information around timeframes of when things are expected to change and a little bit more meat on the bones in terms of what those changes might be. But just as a reminder, the current rules are that there's a 2-year qualifying period for ordinary unfair dismissal, and that's outside of whistleblowing claims. And currently there's a window of 3 months to make an employment tribunal claim. This is likely to change to a day one unfair dismissal claims with the initial employment period. And it's still not confirmed how long this initial employment period would be, but it's likely to be around 9 months. And then this is now expected to come into play in 2027. So that means that they will take away the 2-year qualifying period, and there will be a day one unfair dismissal right that will come into play. The time frame also in terms of being allowed to make an employment tribunal claim will be extended to 6 months, and that's expected to take place in October 2026. So that's really not very far away in terms of where we're talking about the changes, and some of them are going to be really, really big changes that we'll talk about today. So that's going to be in place, or we're expecting that to be in place in October next year. There's a caveat, as with lots of these things, as Jackie's already mentioned, that one, it's still got to go through Parliament and royal assent, but also there's been a political change in the UK over the weekend. The Deputy Prime Minister has resigned, so there will be changes in the senior leadership team in the government. So the previous Deputy Prime Minister was a very strong supporter of lots of these changes, and we don't know who's going to be replacing her. We'll talk about that a little bit more detail later, but we don't know if these proposals will stay in place or whether they will change or be tweaked again. So watch this space to see what's going to be changing in the future. And then just to talk about what this change means for you. So there will be an increase in risk in terminations and potentially an increase in claims as well. It's really, really key to have robust processes in place. So have a look at your promotion process, your performance improvement plan process. Do you currently do appraisals? It will be really, really essential that these will be documented going forward to be able to back up the case of why you're looking at dismissing someone. There will be a statutory probation period, and that's expected to be 9 months. And it's likely that you'll need to be having a look at what your line managers currently do. So it's really, really important to get your line managers in good habits now. We are talking about timeframes that are in the future, but it's really important to get your line managers into good habits now and moving forward. So that's having clearly documented meetings, giving clear feedback, having those difficult discussions rather than being put off or not being dealt with until the point of dismissal. We find a lot of clients come to us where they haven't necessarily communicated any problems or issues with the employees, and that's going to be really, really important moving forward. Have a look at your recruitment processes and your induction and probation processes to make sure that they're robust and well documented. Have a look at recruitment and induction. Do you have at least 2 stages in your recruitment process? It's going to be really important to look at and make right decisions of who you bring into the business. Do you use any personality profiling tools? What tools do you use to actually recruit and make those recruitment decisions? Do you have a robust probation process? Does it cover the training needs of the people that you're bringing on board to give them the best chance to succeed? And again, is this documented? Also, don't delay in making those difficult decisions. Review underperforming employees now. It will become riskier as the scope of unfair dismissal claims widens. As I've already mentioned, clients often reach out to us wanting to dismiss someone, or they have someone who's underperforming, and there isn't sufficient documentation or processes in place at the moment to make a safe exit, and that's going to be even more important moving forward. So in the future, it's really key that you have a robust performance improvement plans for any underperforming employees, and it's really important that these things are reviewed regularly and well documented. And as I've already mentioned, it's really, really key to upskill your managers. So have a look at what you already have and train your managers to get up to speed before these changes come into play. And now I'll move over to Jackie, who's going to talk about the next topic.
Okay. So I'm going to talk about collective redundancy rules. So this is not for small scale redundancy consultations, but where you have 20 or more employees affected by redundancy. So the current situation is that where an employer is planning 20 or more redundancies at one establishment within a rolling 90-day period, they must at that point consult with representatives of the affected employees. So, under the current rules, establishment generally means one workplace or site. The consultation must begin in good time and at least 30 days before the first dismissal is proposed. And this then rises to a minimum of 45 days if the proposal is to dismiss 100 or more employees. If there is a failure to undertake proper collective consultation under the rules that I've mentioned, then this could result in protective awards against employers of up to 90 days pay per employee. So we are seeing suggested amendments to this, where the Employment Rights Bill would change the threshold that triggers the need for collective redundancy consultation. They haven't very helpfully given us any stats on that, but we know that they will change. We also expect that in 2027 we will see that the one establishment rule that I mentioned for triggering collective consultation will be removed, and employers will need to consider the total number of redundancies across their whole organisation and not just one individual workplace as being whether it is a trigger for collective consultation or not. And then more imminently, in April next year, if you fail to collectively consult on redundancies where the law states that you must under the existing rules, so remembering the one establishment rule will still be in place at that point, there will be double the maximum collective redundancy protective awards from 90 days to a maximum of 180 days pay per employee. So again, just bearing in mind, most of the clients that we deal with do normally or don't normally need to go through collective consultation. Most of the time, they are less than 20 employees who are placed at risk of redundancy. But of course, that could change. So do please bear that in mind. What this means for your business, again, just please do review the scope of redundancies across the business and not just in one location or establishment as and when those rules come into play. Record keeping is going to be key, and be prepared that if you get it wrong, there will be higher penalties as of April next year than what there are currently. So I'll hand back to Helen to talk to you about the many changes coming for family leave and all other sorts of leave.
Thanks, Jackie. Yes, there's lots to get through in this section, so bear with me, everyone. First off, I wanted to talk about maternity leave and the current state of play, and then what's likely to be changing. So there are protections against dismissal of employees on maternity leave or dismissal reasons related to pregnancy, but at the moment, there's minimal specific protections for new mothers. It's like there are going to be changes in April next year, or sorry, there were changes April this year to give extra protections to individuals of those that are returning from family leave, and that's in the scope around redundancy as well. So if you're looking at redundancies, as Jackie's already talked about the other changes, it's really important to look at the scope that you're currently looking at. We do expect that there will be some increased protections that will likely last for 6 months after returning from work, after family leave. But again, we don't have the specific scope of what that will look like, but we do know that changes will come. Next, I'm going to talk about paternity leave. So there's quite a big shift here that's going to be happening. So at the moment, where a father or parent B is taking leave, they will have the option of 2 weeks paid statutory leave. The current statutory rate is £184.03, or 90% of average weekly earnings, whichever is lower. And of course, the business can enhance this if they choose to. Many of our clients do decide to enhance this. But at the moment, there is a qualifying period of 26 weeks of continuous service required by the qualifying week, which is 15 weeks before the birth of the child, to receive this. So this is in place for both the leave arrangements and the pay arrangements. The key change on this is that there's going to be a removal of the service requirement for paternity and parental leave. So from April 2026, there will be the removal of the continuous service requirements to be able to take and request the leave arrangements. So that's a really big shift in terms of qualifying periods for paternity and parental leave requests. And again, that's going to be coming into play, we expect, in April next year. So that effectively means that parental leave and paternity leave will become a day one right, whereas at the moment, you have to have the right service in place to be able to have a legal right to those pieces. So that's a big, big shift. Next, I'm going to talk about parental bereavement leave. So there's some years ago, we had the introduction of parental bereavement leave, and that is in the case of a child's death or stillbirth for pregnancies that are more than 26 weeks gestation period. To be clear, at the moment, there's no paid entitlement for anyone else who has been bereaved in other relationships, in a parent and child relationship, or any prescribed entitlement to time off. So it's up to you and the company to decide, and it's your discretion, or to have a policy in place to outline what time off employees may have, whether that's paid or unpaid, as bereavement leave. And that's both in terms of parental and non-parental leave. Obviously, you've got the statutory leave arrangements that I've just talked about. But many businesses do provide some level of paid bereavement leave. Parental bereavement leave is paid at 2 weeks, statutory rates, which is again £184.03, unless there are other lower earnings to consider. And the key change is going to be that there's going to be an introduction of unpaid bereavement leave, and that's expected in 2027. So this will cover more relationships than a parental and child relationship, and this could be set at 1 or 2 weeks. Again, that hasn't been confirmed, but again, there's going to be a shift in terms of it's not just about a parental and child relationship, it's other leave arrangements, other parental bereavement leave arrangements that are going to be coming into play. There's also going to be an extension to the parental leave criteria to cover miscarriages before the 24th week of pregnancy. And again, that's expected in 2027. So there will be a provision made to extend time off for pregnancy loss. And again, that's a really key and big shift that the government is keen to put into play. So there's quite a few things and quite a big shift coming into place in terms of bereavement leave. It's not just going to be a statutory arrangement for parental and child relationship bereavements. It's going to be a wider scope, and most of those changes we're expecting in 2027. Next, I'm going to talk about sick pay. Again, there's big changes here, and these are likely to happen in April next year. So again, just to recap, currently there's statutory sick pay is payable from the 4th day of absence. So after 3 waiting days, an employee would be entitled to statutory sick pay on the 4th day of absence. The big change, 2 big changes here will be that it will be payable from the 1st day of sickness rather than having any waiting days in place. Also, there is a lower earnings threshold in place, which limits some level of statutory sick pay to some individuals. This will be removed, and it's likely to be replaced by either statutory sick pay or 80% of the weekly earnings, whichever is the lower rate. So there's big changes here in terms of waiting days and the level of pay available for individuals across the board. So there's 2 key changes here, and that's expected change will happen relatively quickly from April next year. Next, I wanted to talk about neonatal care and the leave attached to that. So this change has already taken place. It happened in April this year. And this is for parents of babies that require neonatal care that's in place and that they need to have for at least 7 days, starting within the first 28 days following their birth. So the leave arrangement is for up to 12 weeks of paid leave in addition to other leave entitlements. And the payment will be made at statutory rate unless you choose to enhance it. So there's a day one right to take neonatal leave, and the pay rate for neonatal care pay is again the £187 per week. And it will be available for those who meet the continuous service requirements and minimum earning thresholds. And these are in line with maternity and shared parental leave arrangements that we already have in the UK. Leave will be tagged on to the end of maternity or paternity leave and will last as long as the child was receiving the treatment, and that's capped at 12 weeks. So we've had a couple of cases with clients who we've been supporting with this, who individuals have had babies born that require neonatal care leave at the early stages of their life. So it is in place already, and we are already supporting clients with this. I also just wanted to cover off what these changes mean for you as a business. So and this is across the leave types that we've talked about. So it's likely that there will be an increase in cost for you, even if you are just paying the statutory rates and not any enhancements. In relation to sickness, could it result in more sickness absence for your business because the individuals are entitled to statutory sick pay from day one? In hospitality and retail, we may see an increase in costs. Typically, these industries do pay SSP and mainly don't offer any enhancements on these pay arrangements. However, if you are an employer who do pay leave types on a discretionary basis or have enhanced policies, will it really make a difference because you're already paying an enhanced level? We are yet to see what the changes will mean for you. Practical steps moving forward. So it's really, really important that any leave policies that you have are reviewed and updated. Will you be paying statutory rates, or will you be offering any enhanced leave arrangements? Preparing payroll systems for these changes. You'll need to think about that piece and make sure that you're paying the appropriate rates. Think about how you document these leave types. What sort of tracker do you have in place to support these leave arrangements? How are you holding accurate records for future evidence and also payroll processing? You'll need to inform and train managers on these different leave types. There's some new leave arrangements that have come into place, and there's significant changes to a number of leave types that we already have in the UK. And in terms of bereavement and neonatal leave, consider the support that employees might need on top of the pay arrangements. Do you have any counselling services available that you can offer to individuals? What other wellbeing pieces do you have in place for your business? And then finally, on my part for this piece, to talk about what it means for your business, it's really, really important to remember it isn't impossible to terminate an employee on maternity leave or a returning mother or a pregnant employee. But of course, you need to use the usual requirements of fair investigation and processes, and that would apply for performance and any disciplinary matters as well. For redundancies under the current legislation, pregnant employees or returning mothers have enhanced redundancy protections for up to 18 months from the start of maternity leave. And so that might be looking at priority over colleagues of a suitable alternative role. So it's really important, again, to link back to your record keeping. And as Jackie said, to look at the reasoning around your redundancy considerations. However, where there is a genuine business case to remove a role and all employees are being made redundant in that post, or it's a standalone role which other employees don't occupy, it's only one individual in that position, then redundancies can still happen. So again, to recap, it's the current, you need to have a review of the current leave arrangements and to consider enhancements if you are going to offer anything over the statutory arrangements. And if you are going to put those in place, we always suggest that you have a policy outlining what those arrangements are. So I know that was quite a lot on leave arrangements. So I'm going to hand over to Jackie to talk about flexible working.
Thanks, Helen. So I'm conscious of time, so I'm just going to whiz through the next couple of sections. First off, we have flexible working. So this is another change which has taken its time to become part of UK legislation. The current situation that we have is that employees can make a flexible working request up to twice per year, and requests must be handled in a reasonable manner, and they are possible to be refused as long as they sit within one of eight fair reasons or eight set of legal reasons for refusal. Going forward from 2027, employers need to make or provide very clear reasoning as to why they are refusing the request. So there are still the same eight grounds for fair reason for refusal, but the key change would be that as an employer, you will now need to go one step further. You must explain and evidence why you consider it reasonable to refuse the request based on one or more of those eight grounds. And you will need to explain the specifics and justify your reason to decline. So you can't just state that you're refusing and doing a copy and paste from the UK Gov information. You need to go that step further and really justify that with genuine reason. And what that means for you is a possible increase in requests. So there's already been quite a lot of press in the UK about return to work in the office and flexible working arrangements, and maybe what some companies are doing to kind of strong arm their employees back into the workplace. So there is a possibility you might see an increase in requests for home working and so on. You need to be fair and consistent with your decision making. Maybe consider trial periods where you have said yes to a flexible working change, and just see whether it works out for you. You need to update your policies and ask if managers have got the skills to manage remote workers, because of course, if you are saying yes to home workers, you need to know that that's going to still work for the business. And one key thing is really to move away from an immediate reaction to decline. We are in a new world now, so we're led to believe at least, and we need to embrace flexible working or be open-minded. Of course, bearing in mind and caveating that there are some roles where home working, as an example of one type of flexible working that could exist. Home working may not work for all, such as in retail or in the restaurant industry, as an example, to state the obvious. But it should really be easy to evidence why you are refusing in those circumstances. So the next change that we will see is around tipping. So the Employment Allocation of Tips Act 2023 came into force on the 1st of October 2024, requiring employers to pass on 100% of tips to workers without deductions other than the usual tax and national insurance. You must share the tips between workers in a fair and transparent way. So it doesn't have to be necessarily equal, but you could have a policy to say people in certain roles might receive X percentage of tips. And your policy would reflect that. So you need to have a written policy about tips, how tips are distributed, and records must be kept on history of how tips have been distributed. If your policy is that cash tips are collected and distributed, then they are caught by the legislation. If you permit workers to keep 100% of cash tips individually, then that isn't included in the legislation. So again, that would be included in your tipping policy. And payments to workers must be made by the end of the month following receipt of those tips. And where there are tips received via card payments, so whether that be service charges or tips paid on card, the principles work in the same way, and you need to distribute those tips fairly and in line with your policy. What we are going to see change is a tightening of tip laws from October next year. There will be a need to consult with workers or their representatives on creating a tipping policy. So that's going to be quite a big shift in terms of your freedom to create that policy. So it's not going to be just your decision. And the tipping policy will need to be updated every 3 years. So I'll hand back to Helen to talk about 0 hours.
Thanks, Jackie. Wanted to talk about the current situation for 0 hour agreements. So companies can use 0 hour agreements, and that's usually in place where there's no specific working hours commitment on either side from the employee, from the worker, or from the company. I just wanted to remind everyone that 0 hours should receive holiday pay, and that should be paid at 12.0% of their hourly rate. We still see some clients coming to us who aren't aware of this before we talk to them about 0 hour casual worker agreements. So it's really, really important to review what you currently have in place and make sure that holiday pay is incorporated into your 0 hour agreements. And if there's any backdated or updated agreements that need to take place, then that should happen. And going forward, it means that workers who do undertake regular hours over a period will gain the right to a regular contract to reflect their working hours, giving them a contract with guaranteed hours. They will also have the right to reasonable notice of shifts and compensation when shifts are cancelled or changed at short notice. And what this means for you going forward, it's really key to review your current contracts and shift patterns. Consider engaging workers on a fixed term contract, part-time hours, for example, or consider fixed term contracts if they do have regular working patterns. You need to think about how you currently track your hours and consider implementing a shift tracking tool. Also, you need to prepare for additional costs. So there will be compensation due if cancellation of shifts happen, and there might be a possibility of increased employment tribunal cases around this piece as well. Just a final note in to say that this will include agency workers, and it's expected that the increase in costs or the costs incurred for cancel shifts will be passed on to the end client. So if you're cancelling a shift, you will then need to pay the agency, who will then need to pay the agency worker for the cancelled shift arrangements. So there will be increase in costs across the board. I'll pass back to Jackie to talk about fire and rehire.
Thanks, Helen. So the current situation on fire and rehire, in case you don't know, fire and rehire is where an employer dismisses employees and then offers to re-engage them on new and often less favourable terms as a result of the employees having refused to accept those proposed contractual changes. So while it isn't currently illegal, it is contentious, and it's been heavily criticised in the press by some larger companies employing these tactics, and it's certainly not best practice. So change is coming. This is something that we have been speaking about for a while. But although the dates and details may change, at least at the moment from October 2026, there will be a restriction on the use of fire and rehire unless in limited circumstances. So the bill coming will make it automatically unfair to dismiss an employee for refusing a contract variation. Any dismissal will be considered automatically unfair if the principal reason for dismissal is either that the employee refused to agree a variation of contract, or to enable the employer to recruit another person or rehire that employee under new terms but with substantially the same duties. So if you remember the day one rights that Helen was mentioning concerning unfair dismissal, the 2-year window will be gone once this fire and rehire change will come into force. So even if you have people on short-term service, then this will still apply to them. There will be a very limited exception. So where the employer is in dire financial straits and they're about to collapse, so that is very clear that, it needs to be in extenuating circumstances, then fire and rehire exercises would be accepted if that was the only essential way to get through this particular situation for the employer. But otherwise, it's not going to be permitted. What does it mean for your business? So failure to follow the new rules could lead to an increased risk of unfair dismissal claims, and tribunals may impose financial penalties for non-compliance. There will be a greater administrative burden, so SMEs will need to formalise consultation processes, they will need to document the rationale for changes and demonstrate efforts to reach agreement with employees. And there will be time-consuming consultation processes, of course. Practical tips for how to circumvent any issues that you might face would be to engage early and communicate transparently, ensure that contracts allow for some flexibility in changing terms within reasonable time limits and that your policies are up to date. For significant contractual changes, we recommend that you get legal advice early, and equip your management team with the skills and knowledge to handle those consultations and negotiations. And ultimately, just as a passing word, employees may not have wanted or be happy with the outcome of a process that will change their T's and C's. But if they understand the reasoning behind it and believe that the manner of the process has been carried out properly and was fair and respectful and aligned with the values of the business, then there is an improved chance that you'll be able to move forward with those employees and that they may eventually agree to the terms that you're proposing. So yeah, consultation would be the best way forward. I'll hand back to Helen to talk about harassment.
Thanks, Jackie. So for some years now, employers have not been liable for third-party harassment. So that's harassment by people who aren't other employees, such as customers and service users. But in October 2024, there was new legislation that was introduced as a new protective duty for employers to take reasonable steps to prevent sexual harassment of their employees. So as a team, we've been talking about this for quite some time now, in terms of putting policies in place and training in place for your businesses. But the key changes going forward will be that the new bill imposes a direct liability for employers if they fail to take all reasonable steps to prevent harassment by third parties on their workforce, and that will be in place from October 2026. Also from October 2026, there'll be a requirement for companies to take all reasonable steps. At the moment, it's reasonable steps, but it will become all reasonable steps to prevent sexual harassment of their employees, not just reasonable steps. In April 2026, there'll also be the introduction of whistleblowing protections to protect disclosures of sexual harassment. And then from 2027, there are plans to be regulated to specify steps that are deemed to be reasonable to determine whether an employer has taken all reasonable steps to prevent sexual harassment. So the implications for you and your business. So tribunals already have the power to uplift sexual harassment compensation by 25% where an employer has been found to be in breach of the duty. The level of expectation of what you will need to do will be raised, including carrying out risk assessments, having policies in place, having clear processes for reporting and handling complaints, and some practical steps that you can put into place. The proposed changes to the legislation on sexual harassment in the workplace are already in place, but more emphasis will be on you, the employer, to take all reasonable steps to prevent sexual harassment in the workplace. You've already had the duty of care to protect employees from harassment, not just sexual harassment, but having clear policies in place on what is acceptable and unacceptable and how to report such unacceptable behaviours is a basic requirement and is really key. You should think about training your employees on harassment and be clear that harassment, whether the employee is a recipient or a perpetrator of such behaviours, is unacceptable, whether that be a fellow colleague, other parties that they interact with at work, for example, suppliers or customers. So start putting clear procedures in place. Look at risk assessments, updating or putting in place policies and reporting procedures, and how you handle complaints is really important going forward. And I'll hand back to Jackie to talk about trade unions.
Thanks, Helen. I just wanted to note that I recognise that we're running over time, so this session is being recorded. If obviously, I'd love you to stay with us, but if the session is being recorded, if anyone does need to drop off, so do apologise that we're running over, but please do bear with us. So in terms of trade unions, most private sector employees, to note, are not usually members of a trade union in the UK. But there will be some changes coming within 2 months after the bill becomes law around logistics on industrial action and voting on action. I won't go into too much detail about those elements here. It probably won't really be too relevant for you to be knowledgeable of in your workplace at the moment. But topically, for what is happening in London at present, for the tube strikes, we need to recognise that most strike action does occur with unions and their members. It is expected that the rules around minimum service levels for strikes will be removed. So this change is expected to happen as soon as the bill becomes law. And dismissal for taking part in industrial action is expected to become automatically unfair. So this will remove the existing 12-week limit for claiming unfair dismissal. This change is expected within 2 months after the bill becomes law. Going forward into 2026 and 27, so in April next year, we are expected to see the simplifying how a trade union can gain recognition in a workplace. And also allowing trade union members to vote electronically. Then from October next year, there will be a new duty to inform workers of their rights to join a trade union. So that is the new duty for you as an employer to inform workers of their right to join a trade union. So it is suggested that this should form part of their contract of employment and company policy so that you are meeting those new duties. Trade union representatives will also have the right to communicate with employees in the workplace, for which they should have a right of access. And then trade union reps will receive stronger legal protections from unfair treatment, dismissal, or victimisation by their employer. And there will also be a new right to time off for union equality representatives in order to carry out their duties. So what this means for you as an employer, you will need to change your employment contracts when the change comes into effect, as I've just mentioned there about your new duty. And also expect that there will probably be an increase in membership for people becoming union members and trade union reps attending formal meetings. So if you are running disciplinary processes or grievances or redundancy meetings, then you might see the dreaded trade union rep accompanying your employee to those meetings as a byproduct of the likelihood of there being more union memberships in existence in the private sector. I'll hand back to Helen to talk about the Fair Work Agency.
Thanks, Jackie. So from April next year, there will be an establishment of a Fair Work Agency in the UK. So this is a new body in the UK. And although it's being established in April next year, it's probably not going to become operational until the autumn of next year. So it brings together different government enforcement bodies and different agencies, and they'll have the power to enforce payment of statutory payments, bring employment tribunals on behalf of individuals, and provide legal assistance, support, or representation when individuals have raised claims themselves. It will be responsible for overseeing and enforcing specific employment law rights, and that includes national minimum wage, which is currently under the remit of HMRC, and statutory holiday and sick pay. Given the remit of the new FWA, you should really look at organisations employing lower paid or flexible workers are likely to be most affected. However, all workers are entitled to holiday pay, and this is often a complex area of law. We've already talked about the 0-hour workers and the right to holidays in the session earlier. The risk of error is particularly high in areas prone to confusion, such as calculating holiday pay, where bonuses, commissions, or irregular part-time hours are involved. In short, all employers are at risk of enforcement action, and the penalties can be significant. Where holiday pay has been paid incorrectly, the cost of rectifying this across an entire workforce can be substantial. With the new powers enabling a 200% penalty and claims reaching back to up to 6 years, employers will need to take this issue very seriously. It's likely that the agency will have authority to enter premises and inspect documents and computer records. It's likely that the failure to comply may constitute a criminal offence, and in some cases, employers could also be required to sign a labour market enforcement undertaking, obliging you to follow specific instructions, such as maintaining detailed holiday records. Breaching such an undertaking could result in fines or imprisonment. Where the agency finds that there has been an underpayment, including holiday or sick pay, it will issue a notice of underpayment, and you'll have 28 days to pay these monies. It will include the underpayment going back as far as 6 years and for multiple staff members, if applicable. A 200% penalty will also be applied in addition to the underpayment, and this is where the impact of the agency powers will be most strongly felt. While the penalty can be capped, it is expected to be at least £20,000 per worker. However, it is likely that if the payment is made within 14 days, the penalty will be reduced to 100%, but that is still effectively doubles the amount that you would owe. It does look like that honest mistakes will not constitute as a defence. In addition, the benefit from the reduced penalty, the employer must accept the decision without challenge. This may lead to some to pay rather than appeal, potentially limiting the development of case law in this area. So things that you can do to start preparing for this now is to start preparing now. You need to have a look at your internal pieces around holiday pay and other statutory payments, and that will be really key. How is this monitored? How is this paid? Inspections are likely to be unannounced, so it's essential that you ensure your processes are already in order. Even fully compliant employers will need to review their procedures and record keeping to ensure that you have the required documentation if it's requested. And under the new regime, failure to keep adequate records will become a criminal offence with unlimited fines for non-compliance. So it's really, really key to have a look at what you've currently got in place, and if it's not adequate, then making it so as quickly as possible, so you have the records in place and you're making payments correctly. And then I will pass back to Jackie, and we will talk about the roundup of what we've spoken about and some changes that might be happening going forward. Oh, Jackie, you're on your mute.
Sorry, I can't see you, Helen, either, and then I'm muted myself and off to a good finish, are we? Okay, so yeah, I'm conscious that we are over time, but I just a couple of notes that we thought we wanted to raise. So again, the political climate in the UK is quite volatile now, as if anyone reads the press, we'll know that it's maybe not so great a place to be at the moment between the strike action and the controversial immigration conversations, shall we say, that are happening at the moment, or perhaps lack of. So a couple of headlines that obviously we've touched on is, of course, Angela Rayner, the Labour deputy leader, stepped down, and it's still up for debate as to who is going to replace her. But whoever does will no doubt bring in some of their own views and influence and agenda. And so that will maybe shape future policy. And we may be sat here in March next year telling you that there's further changes again, and the proposed timeline for what we've just discussed may have moved or altered or adjusted. So stay with us and let's see what happens. But also something else to talk about on the immigration side. So it caught headlines this week. The new Home Secretary, Shabana Mahmood, made headlines where she was commenting that the UK could suspend visas for migrants who are looking to travel from countries who do not agree a return deal for migrants. So that means that if the UK wished to deport citizens of certain countries who were in the UK, who usually they may have been refused asylum seeker status, as an example, if those countries do not take their citizens back, then the UK will be suspending visa entry for migrants looking to travel from those countries legitimately under a sponsored worker visa, as an example. And that could make things more complicated for UK employers when we take into consideration where our UK talent pool comes from. And some of the countries listed on there, I don't remember where they were now, Helen. I know India was on one of the countries that was named.
Yeah, there was an
Yeah,
article on the BBC a few days ago, and they were citing India, Pakistan, Nepal, and a couple of other
yeah,
countries.
yeah. So there's quite a lot happening at the moment that might change what we are talking about next year. But as we've already mentioned, the much of what we've talked about today is still going through Parliament at the moment, and it's awaiting royal assent. But I think for the most imminent changes, we're fairly sure that they will happen as and when they've been sort of time stamped to be. But if anything should change, then of course we'll let you know via our HR newsletters and webinars as usual. Other than that, if anyone has, I don't think we've had any questions come in.
Not had any.
Yeah, okay, fine. Anything else that you'd like to add, Helen? Or
No, just to say that there's quite a lot there, and with the political changes, yeah, we're expecting some tweaks, but we don't know how big or small they will be until they are announced going forward. So yeah, just watch this space, and as Jackie said, we'll let you know as soon as we know what the changes are.
Amazing. Thank you, Jackie and Helen.
Thanks.
Sorry for that little run over we had, but hopefully you found this session informative. And as always, all our other webinars can be found on our website, and I'll make sure to have this sent out to you all by the end of the day. So thank you very much. And